The Supreme Court just made an emergency intervention into American gun law. And if you think you would have heard about it from the major networks, you have not been paying attention. This is the kind of decision that reshapes the daily lives of tens of millions of Americans, the kind that attorneys are already using to file new challenges in state after state, the kind that state legislatures are scrambling behind closed doors to respond to, and most people woke up this morning with absolutely no idea it even happened. That ends right now. We are talking about a Supreme Court emergency move that could fundamentally alter gun permit rules for every single American in every single state. 22 million permit holders, hundreds of active Second Amendment cases in federal courts, a constitutional battle that has been building since 2022, and one emergency order that just changed the entire trajectory of that fight. If you have been following Second Amendment law, you know how rare this is. If you have not, you are about to understand why this matters more than almost anything else happening in the legal system right now. Before we go any further, if you care about what is actually happening to your constitutional rights, not the version that gets filtered through political spin and media silence, then hit that subscribe button right now. This channel covers what the mainstream won't. And on a story this important, you cannot afford to miss a single update. Let's get into what actually happened and why the Supreme Court felt it could not wait. The Supreme Court does not grant emergency relief casually. Out of thousands of applications filed every single year, the court steps in on an emergency basis in only a tiny fraction of cases. When it does, it means something is genuinely broken in the legal system below, that waiting for the normal timeline would itself cause an irreversible constitutional injury. That is exactly what happened here, and understanding why requires going back to 2022 and one of the most significant Second Amendment rulings in American history. In New York State Rifle and Pistol Association versus Bruen, the Supreme Court established a new constitutional standard for evaluating gun laws. It threw out the old balancing test that courts had been using for decades, the one that let judges weigh public safety interests against Second Amendment rights, and replaced it with a strict historical test. Under Bruen, if the government wants to restrict your right to carry a firearm, it has to find a genuine historical analog, a real law from the founding era or the period shortly after that matches what it is trying to do today. Not something vaguely similar, not something that kind of resembles it. A genuine match rooted in the actual history of this country at the time the Constitution was written. That was the new rule. That was what the court said states had to do, and what followed was one of the most deliberate, systematic acts of constitutional defiance this country has seen in recent memory. Within 18 months of the Bruen decision, at least 11 states passed a combined total of more than 30 new gun restriction laws. 30 laws in 18 months. But here is the critical part. These laws were not passed to comply with Bruen. They were passed to get around it. States looked at the Supreme Court's ruling, decided they disagreed with it, and went to work engineering a new generation of restrictions specifically designed to produce the same practical result as the laws Bruen had struck down, making it nearly impossible for ordinary law-abiding citizens to actually use their carry permits in everyday life, while technically looking different on paper. They banned carry in so many categories of public spaces that permit holders in states like New York, California, and New Jersey effectively found their permits rendered meaningless the moment they walked out their front door. Sensitive locations, restricted zones, private property default prohibitions. The list grew and grew until the right to carry existed only on paper. One state pushed this strategy so aggressively, so comprehensively, that permit holders filed an emergency application directly to the Supreme Court, not to a district court, not to a circuit court, directly to the highest court in the land, arguing that every single day this law remained in effect was another day their constitutional rights were being actively and deliberately violated. And the Supreme Court agreed that this could not wait. That is how serious this is. That is the environment that produced this emergency intervention. and it raises a question that most Americans have never actually thought through. What does your carry permit actually protect you from, and how many places can you realistically use it? The lawyers who argued against these permit restrictions made their case with a clarity that is worth understanding in full, because the arguments they made do not just apply to one state. They apply everywhere. The logic is straightforward. The Second Amendment protects the right to carry a firearm. The Supreme Court confirmed that in Bruen. Once that is settled, and it is settled, the government has one job: show that the restriction you want to impose has a genuine historical analog in early American law. Find the founding era equivalent. Prove that the framers of the Constitution would have recognized this kind of regulation as consistent with the right they were enshrining. That is the test, and the challengers argued that these states cannot pass it because the kinds of sweeping, comprehensive, location-based carry restrictions they are imposing simply did not exist in early American history in any form that resembles what these states are doing today. But there is a layer to this argument that goes beyond legal technicality, and it deserves to be said plainly. Several of the historical laws that anti-gun states most frequently cite when trying to justify modern restrictions were originally enacted specifically to disarm Black Americans in the aftermath of the Civil War. These were not neutral public safety regulations. They were instruments of racial terror and political subjugation, passed by state governments that had just lost a war, fought over the right to hold human beings in bondage, and were determined to preserve as much of that power structure as possible by disarming the people they had previously enslaved. Organizations like the Firearms Policy Coalition have documented this history extensively. And yet these laws keep getting cited in federal courts as constitutional precedent for modern gun restrictions. Think about what that means. States arguing that your Second Amendment rights can be curtailed are doing so by pointing to laws whose entire purpose was the systematic disarmament of Black Americans. That is not just legally questionable. It is historically indefensible. And any court that accepts that argument should be forced to say out loud what it is actually doing. Now, to fully grasp why this case matters beyond any single jurisdiction, you have to understand something that most Americans genuinely do not know about the country they live in. Right now, in 2026, there are effectively three completely different legal realities operating simultaneously when it comes to your right to carry a firearm. And the gap between them is not a small procedural difference. It is a constitutional canyon. In more than 29 states, you do not need any permit at all to carry a concealed firearm. This is constitutional carry, and it means the government has accepted that your right is self-executing. You are a law-abiding citizen. You do not need to ask permission to exercise a constitutional right. That is the law in more than half the country. In most of the remaining states, you can obtain a permit if you meet clear, objective, non-discretionary requirements. Pass a background check, complete a safety course, pay your fees, submit your application. Meet the criteria, get the permit. The system works the way it is supposed to work. And then there are the states, the ones at the center of this legal battle, where the government has claimed the power to simply say no. Where even if you meet every requirement on paper, bureaucratic discretion, arbitrary location restrictions, and an ever-expanding list of prohibited zones can render your permit functionally worthless. Two people can clear the same background check, complete the same training, obtain the same permit, and live completely different constitutional lives depending on which side of a state border they happen to sleep on. According to the Crime Prevention Research Center, there are now over 22 million concealed carry permit holders in the United States, 22 million Americans who went through the legal process, who cleared background checks, who completed training, who paid fees, who did everything the government asked of them. And in California, New York, New Jersey, and Illinois, millions of those same Americans step outside their homes and find that their permit is effectively decorative. Because between sensitive location laws, private property default prohibitions, and a list of restricted zones that seems to grow with every legislative session. There is nowhere left to actually exercise the right. That is not regulation. That is nullification. If you live in a constitutional carry state, a shall issue state, or one of these restrictive environments, drop it in the comments below, because the conversation happening in that comment section is going to make absolutely clear how differently this issue lands depending on where you live, and why a national resolution to this legal chaos is not just desirable, it is constitutionally necessary. At the center of this emergency case sit 4 constitutional questions, and every one of them has implications that extend far beyond the specific law being challenged. The first is a question about the historical analog standard itself. How close does a historical law actually have to be to justify a modern restriction? The government wants a loose standard, one where rough similarity is enough, where a court can point to some obscure 19th century ordinance and say, close enough. The challengers want a strict standard, one where the match has to be genuine, specific, and historically honest. This is not a minor procedural dispute. A loose standard gives states an almost unlimited toolkit. With enough legal creativity, you can always find some old law that kind of resembles what you are trying to do. A strict standard actually forces the government to prove its case. The Supreme Court's answer to this question will ripple through every Second Amendment case currently working through the federal courts. The second question is whether a law that looks neutral on paper can still be unconstitutional because of what it actually does to people's rights in practice. A law that technically permits carry, but then bans it in 70% of accessible public spaces, does not protect the right to carry in any meaningful sense. The question is whether the court will look at what these laws do to real people in the real world, or whether it will let states hide behind formal legal language while achieving a practical prohibition. The third question is whether the Bruen standard applies to all forms of permit restriction or only to outright bans. Some lower courts have been trying to draw a line, arguing that Bruen only prohibits total prohibitions and that heavy, comprehensive regulation is still fair game. If that interpretation is allowed to stand, Bruen becomes almost meaningless. It would create a regime where states can never ban carry outright, but can regulate it so heavily that the result is indistinguishable from a ban. The fourth question is about public safety arguments. Bruen was explicit. Public safety concerns alone are not enough to justify a gun restriction. You need historical grounding. But state after state keeps letting public safety arguments re-enter the analysis through the back door, and some lower courts have been willing to let them. The Supreme Court needs to close that door firmly and permanently. According to the Constitutional Accountability Center, there are currently more than 150 active Second Amendment cases working through the federal courts right now. Every single one of them is waiting on how the Supreme Court answers these 4 questions. This is not a case about one law in one state. It is a case that sets the rules for 150 legal battles simultaneously. When the Supreme Court's emergency stay came down, its effects were immediate and concrete. The most direct consequence was simple. The challenged law was paused. In the jurisdiction where these restrictions were being enforced, permit holders who had gone to bed one night, effectively unable to use their permits in most public spaces, woke up the next morning in a legally different situation, overnight. That is what an emergency stay does. It does not wait for briefs and oral arguments and months of deliberation. It says, while this legal question is being resolved, the status quo that existed before this law was passed is restored. For people who have been fighting these restrictions for years, who have watched their constitutional rights get legislated away piece by piece, that kind of immediate change is not an abstraction. It is real. And the effects extend beyond the specific jurisdiction where the stay was issued. According to legal analysts who track Second Amendment litigation, citations to Supreme Court emergency orders in lower court Second Amendment rulings increased by more than 40% in the 2 years following Bruen. Lower court judges are watching. They see what the Supreme Court does even in emergency posture, and they adjust their own rulings accordingly. A Supreme Court emergency stay is not just a pause, it is a signal, and that signal is already being received. The reactions from organized advocacy groups have been predictable and predictably revealing. Gun rights organizations, the Firearms Policy Coalition, Gun Owners of America, and others are treating this as a validation of the legal strategy they have been executing since Bruen. But more importantly, they are doing something less visible and more consequential. They are identifying the next set of cases to file. They are using this emergency order as a new legal foundation to build on. They are not celebrating, they are accelerating. On the other side, gun control organizations like Everytown for Gun Safety and Moms Demand Action moved immediately into damage control mode. Two of the most well-funded advocacy organizations in the country, with a combined annual budget exceeding $100 million according to their own public filings, issued statements framing the decision as dangerous and calling on state legislators to find new approaches to public safety. What that actually means, translated out of advocacy language, is this: they are already drafting the next version of the law. The emergency stay has barely settled, and the machinery is already in motion to engineer a replacement. That is the cycle. Court strikes it down, legislature finds a new way to do the same thing, back to court, repeat. The difference now is that the Supreme Court appears to be paying attention to the pattern. And here is the data point that tends to get lost in the political noise around this issue. According to the Crime Prevention Research Center's analysis of Texas data from 2021, concealed carry permit holders were convicted of crimes at a rate more than 18 times lower than the general population. 18 times. The people fighting for the right to carry in public are statistically among the most law-abiding citizens in the country. The narrative that expanding carry rights means more crime is not supported by evidence. It is a political argument dressed up as a public safety argument, and the courts are increasingly treating it as such. Are you watching, subscribing, and staying with us? Because what comes next in this legal process is where the real stakes come into focus. And this is exactly the kind of journalism that needs an audience that refuses to look away. Subscribe now if you have not already. This story is not over. It is just beginning. Looking forward from this emergency order, the potential policy consequences are sweeping in a way that has not been true of any Second Amendment development since Bruen itself. The most significant possibility on the horizon is what legal scholars are beginning to call a de facto national floor for carry rights, a minimum constitutional standard below which no state can go when it comes to issuing permits and ensuring that permit holders can actually use them in practice. If the Supreme Court writes a broad opinion in this underlying case, one that explicitly identifies and prohibits the functional nullification strategy that restrictive states have been using, it would force every state in the country to maintain a carry rights system that is genuinely functional, not just technically legal. Beyond that, a strong merits ruling could accelerate legislative momentum towards something that tens of millions of permit holders have wanted for decades: genuine national reciprocity. Right now, the Law Enforcement Officer Safety Act allows qualified, active, and retired law enforcement officers to carry concealed firearms across state lines, a right that ordinary law-abiding permit holders with valid licenses do not have. A truck driver who is a licensed concealed carrier in Tennessee can find himself in criminal jeopardy the moment he crosses into a restrictive state. Even though he is exactly the kind of responsible, law-abiding citizen the permit system was designed to authorize, that asymmetry is not a feature of constitutional law. It is a policy failure, and a broad Supreme Court ruling could create the legal and political environment in which Congress is finally forced to address it. The public opinion landscape is also shifting in ways that matter for long-term policy. According to a 2023 Gallup poll, 56% of Americans support concealed carry rights for law-abiding citizens, a number that has grown steadily over the past decade. The legal momentum in the courts and the direction of public opinion are converging at the same time. That kind of convergence is rare in American politics and law. When it happens, it tends to produce lasting change rather than temporary shifts. None of this is guaranteed. The court still has to issue a full merits ruling, and the timeline for that matters. Supreme Court terms run from October through late June or early July of the following year. If this underlying case is on the current term's docket, a full opinion could arrive as early as this coming spring. If it carries into the next term, Americans might not see the final ruling until mid-2026. Every month between now and that ruling is a month during which state legislatures will be maneuvering, advocacy groups will be fundraising, and lawyers on both sides will be reading every word the justices write. Not just the majority opinion, but every concurrence and every dissent, looking for language they can use in the next challenge, the next motion, the next filing. According to research published in the Stanford Law Review, language from concurring opinions in major constitutional cases is cited in subsequent lower court rulings at a rate nearly equal to language from the majority opinion itself. That means every single word written by every single justice in this case carries weight that extends far beyond the immediate outcome. Lawyers will be building arguments around the nuances of this opinion for decades. What this means for you, right now, today, depends on where you live and what kind of permit regime you are living under. If you are in a state directly affected by the law that was stayed, you need to talk to a qualified attorney about what your current carry rights actually are, because the legal landscape shifted. If you are in California, New York, Illinois, New Jersey, or any other state with a post-Bruen restriction framework, you need to understand that legal challenges to those frameworks are coming, and this emergency order just made them significantly stronger. If you are in a constitutional carry state or a functional shall-issue state, you are watching this from a distance, but do not make the mistake of thinking it does not affect you. A Supreme Court opinion that establishes a national floor for carry rights or accelerates reciprocity legislation reshapes your rights too. The Supreme Court does not always get things right. Institutions rarely do. But in this case, the justices are being confronted with something that cannot be rationalized away. A pattern of deliberate, coordinated constitutional defiance by states that disagree with a ruling they are bound to follow. That is not federalism. That is not democratic experimentation within constitutional limits. That is a power structure telling ordinary Americans that their constitutional rights exist only to the extent that the state finds it politically convenient to honor them. And that is the fight. Not the legal jargon, not the procedural posture. The actual fight underneath all of it is about whether the Bill of Rights means what it says, or whether it means what the government finds acceptable this year, in this state, under this administration. The Second Amendment says, the right to keep and bear arms shall not be infringed. Not shall not be unreasonably infringed. Not shall not be infringed unless a state legislature finds the policy unacceptable. Shall not be infringed. The Supreme Court's emergency intervention is not the end of this story. It is the moment when the court signaled that it is paying attention, that it sees the pattern of defiance and is not willing to let it continue unchallenged. The full merits ruling, whenever it comes, will be the answer. And that answer will shape the constitutional rights of every American who has ever held a carry permit, every American who has ever wanted one, and every American who has ever wondered whether the rights written into the founding document of this country are real or merely rhetorical. We will be here covering every development as it happens, every brief, every oral argument, every opinion. Because this is exactly the kind of story that the mainstream media will undercover, underanalyze, and underestimate, and you deserve better than that. If this gave you something real, something you did not get anywhere else today, then like this, share it with someone who needs to hear it, and subscribe so you never miss what comes next. The final ruling on this could be months away. Stay with us for every step of the journey.